reputed college and has been time and again recognized on different platforms as one of the best, sometimes one of the best institutions down south, sometimes one of the best private colleges disseminating knowledge pan India. And be that as it may, and today we have amongst us Dr. Malika Arjun, who has otherwise been connected with us while we have been doing webinars, but today we actually become their knowledge partners. And those who have been connected with us on this platform, we all know that today's resource person, Mr. Vishwanath Angadi, a former Principal City Civil Session Judge, Karnataka, and a renowned arbitrator, has already given 2 sessions, and consequently keeping in view that his sessions were well received, and a topic of money suits under the CPC, a summary suits procedure, under Order 37 to be precise, and the Limitation Act is one of the gamut which everybody wants to understand, especially more so in view of the Commercial Act proceedings of 2015 as to whether what could be the way forward amongst the two, and how the Limitation Act would ruin, how the we have the defense of the defendant or the respondent, as we say, and what are the judgments, and whether this provisions is actually a boon or a bane. And as we all know, there's a subtle difference between a summary pursuit and a regular suit. As we felt that this topic is of immense knowledge, immense importance for the purposes of students as well as the professionals, so why not connect with a person who has been closely associated with it on the judicial side and at the same time on the academic side with the KLE College. And as they say, one is alone and 2 is a company, but I won't say that third makes it a crowd. But I can only say that we 3 will work together for the betterment of the spreading of the knowledge. Without taking much time, I would request Mr. Vishwanath to take over. Thank you, sir, for connecting and agreeing to share the knowledge. Unmute. So you will have to unmute yourself.
Yes, sir. Now you are able to hear me, sir. So thank you, Sri Vikas Charat, advocate, and who is organizing Beyond Law CLC since the past so many months. Dr. Mallikarjunayya, principal of the Law College at Bangalore. Dr. Manoj Kumar Hiremet, advocates across various parts of our country online, and my dear law students. The topic given is very vast, money suit, and that will encompass various statutes, various acts of parliament. To begin with, the basic code is the code of CPC. Number 2 is the aspect of summary suit, summary trial, summary procedure under Order 37 of CPC. Third point is law regarding limitation. What about time limit for the plaintiff to approach the court in an action for recovery of the amount of dues? The fourth point is Arbitration and Conciliation Act, when that one should be invoked by the party, because many times advocates in the court at the fag end, they are asked by court, you approach the forum of arbitration. The fifth important act is Court Fees and Suits Valuation Act. How much court fee have to pay for recovery of an amount of rupees 1 lakh or 1 crore, as the case may be. Whether payment of court fee is a must for recovery of the amount of dues. I will tell you the important niceties, how we can avoid court fee and file a suit for recovery of 100 crores. That also I will tell you now only. The next point is namely Karnataka Small Cause Causes Act. At Punjab also you have got separate act called, Punjab Small Cause Courts Act. And we have got a separate act called as Karnataka Civil Courts Act. Then lastly, the point is Legal Services Authorities Act. I am the plaintiff. I am very poor. How to go to court? I cannot pay court fee. How to go to court? The point is, we have got that particular enactment, and also I got the burdens of the CPC also to deal with a case where I have no funds to pay court fee. With this brief prelude, I will start quickly the aspect of CPC. CPC, as you all know, who teach for one semester, I cannot wind up within 30 minutes. And I will be massacring the paper CPC. If within 30 minutes I will finish off. My point is, I will touch only provisions concerning money suits. That is my important, what you call, aspect of touching CPC. And so also the burdens of Arbitration and Conciliation Act. That's also a very vast topic. We can discuss and talk on the subject for 2 days. 2 days means 2 working days, say 6 hours each. And I will touch only those sections which can be availed of by the plaintiff in an action for recovery of the amount of dues. Our subject is money suits, principally recovery of money, either by a trader or a businessman or a company or a firm or a body corporate or even a society. And here the action is for recovery of money and money only, and not with regard to other items. As regards CPC, I will start quickly the aspect of section 6 of the CPC. What 6 states? 6 of CPC states and contemplates regarding pecuniary jurisdiction of the civil courts. Civil courts shall try suits only of civil nature. Section is 9 of CPC. 6th is, unless the court is competent to try the case filed by the plaintiff for recovery of the amount of dues, the court gets no jurisdiction to file, to take on board the said suit for the purpose of trial. So 6 speaks of pecuniary jurisdiction over suits based on amount of claim made by plaintiff for recovery against the defendant in a money suit. Plaint filed by plaintiff for recovery of 5 crores. Which court can you file? Can you file? And both parties, they reside at New Delhi. Can they jump and file a case before the Supreme Court of India? Original suit for recovery of 5 crores, suit for recovery of 100 crores, parties stay at New Delhi, cause of action took place at New Delhi. Can the Supreme Court of India be asked to take that case, that suit, because cause of action at Bangalore, at New Delhi, parties stay at New Delhi, breach at New Delhi, and Supreme Court of India is also at New Delhi. And parties have got the element, let there be finality of order of the Supreme Court, because there is no other higher court than Supreme Court of India. So the point is, we have to see 6th of the Act. Suit for recovery of 6 crores or 5 crores, we have a civil court, then there is only senior civil judge court. Now we have got common pattern of judges throughout the nation. Formerly we had got the post called as Munsif, who are calling them as civil judge, junior division. Now there is parity with regard to the name structures. Lowest grade, civil judge. Second grade, senior civil judge. Third grade, district judge. Fourth is High Court. Fifth is the Apex Court, Supreme Court of India. So any suit for, in our state of Karnataka, recovery of an amount exceeding rupees 5,000 to 5 lakhs to be filed before the court of civil judge senior division, that is senior civil judge, and suit for recovery of claim less than rupees 5 lakhs to be filed before the civil judge, or is called as civil judge junior division previously. So we cannot file a case of a recovery of 100 crores before the Apex Court, because Supreme Court of India is not the court of original jurisdiction with regard to recovery of amount of dues based on terms of the contract. So that is the first important point. And there, what to touch here also what's called as Small Cause Courts Act, that is Section 8 of Karnataka Small Cause Courts Act says, at Bangalore City, any claim less than 2 lakhs to be filed as a small cause suit only, SSC, small cause suit only, before the Court of Small Causes Court at Bangalore. And any amount beyond 2 lakhs at Bangalore to be filed before the court called as City Civil Court at Bangalore. So at Bangalore, City Civil Court is equal to Senior Civil Court at other districts, and that is the aspect of what's called as the Section 8 of Karnataka Small Cause Courts Act. Then we have got Section 22 of Karnataka Civil Courts Act of 1964. That defines what about the limits of various courts in our state. That states within the state of Karnataka, any claim less than rupees 5 lakhs to be filed before civil judge. Any claim beyond 5 lakhs to be filed before senior civil judge. That is Section 22 of Karnataka Civil Courts Act. Or Small Cause Court, Section 8 of Karnataka Small Cause Courts Act. And both are of 1964. That is the pattern of filing of suits before the courts in our state. And other states may have, materially, the same set of principles that depends upon the state enactments of the concerned states. Small cause courts are there in many states in our country. And we have got Presidency Small Cause Courts Act at the presidency towns of Bombay, then Calcutta, then comes here, Madras, and one more place. So we have to see also those acts, Small Cause Courts Act of the state, Civil Courts Act of the given state, and also CPC, see the amount of claim, then choose the proper court of filing. Because at the end of the day, the judge may say, take back your plaint, go to proper court. Or at the end of the day, the defendant may appear and file application asking the court to reject the plaint under Order 7, Rule 11 of CPC. So to avoid all these things, read also Section 6 of CPC, 8 of Small Cause Courts Act, 22 of Civil Courts Act, and also relevant statutes of the concerned state governments. So that is the first important point. The number 2 is Section 15 of the Act. That states file suit before the lowest court at your place. I said New Delhi, I cannot file a case before Supreme Court of India. I have to approach only the civil court at New Delhi, because there we got civil court at New Delhi, just like Bangalore. So suit to be filed before the lowest court at the place which is competent to try. The word competent means less than 2 lakhs, small cause matter, less than 1 lakh, small cause matter before the civil judge at the other taluka levels. So suit to be instituted in the court of lowest grade at the place, and that court must be competent to try the said case. That is the second important point. The third point is Section 20 of CPC. I told in the case of New Delhi matter, I gave one example, don't mistake me. Party state, New Delhi. Katavaksana arose at New Delhi. I told court at New Delhi has got the power to receive the plaint, but not Supreme Court of India. So 20 says, suit to be instituted where the cause of action arises or the place where the defendant resides. 20 of CPC. You cannot file a suit if the cause of action took place at UK or took place at a foreign country. Suit filed before Karnataka means cause of action within limits of the concerned court or place where the contract was signed by both parties. So, or the place where the defendant now works and earns money. So, resides for gain resides as place of residence, they also give to the court the power to try the case. File case before the court where the cause of action arose or where the defendant reside. That is 20 of CPC. Then 26, filing of suit is not by oral words, filed by a plaint. Plaint means that is a pleading in writing under Order 6 CPC, setting forth names of the parties, date of cause of action, and date of the particular agreement, date of law, all those given details. So, file suit by filing or presenting a plaint before the competent court, which will try the suit in due course of time. So, plaint to be filed under Order 7 of the CPC. 7.2 of CPC speaks of the format of the plaint. What a plaint should contain, all those things are told in Order 7, Rule of CPC, and suit to be filed by filing a plaint under Order 7 of CPC with verifying affidavit of the plaintiff. Plaintiff is signed by the plaintiff, plus there must be affidavit of the plaintiff verifying contents of the plaint. The next point is, yes, you file in court a plaint, say on 11/1/2021 today. The next stage is court will receive the plaint. It will go through everything. If it is in order, it orders issuance of suit summons to the defendant. The defendant is sent suit summons by the court by enclosing a copy of the plaint along with annexures, if any, and that is sent by the court to the defendant for service through the process servers of the court, or it may be also by means of sending by rated post, sending by speed post of India Post, or sending by any mode of which the High Court has framed rules. So that is 27 of CPC, read with Order 5 CPC. Order 5 speaks of service of summons on the defendant. In what mode? What discussed there at the concerned point of time. The next point is regarding procedure. I will tell in the second part. I will just tell only the substantive aspect of the CPC in the beginning. Then comes the court holds that the plaintiff's suit must be decreed. Then the court has to also award what is called as interest. Amount of claim is 5 lakhs. Loan amount given is 1,116, and suit is filed in time. And today, the court wants to allow the suit as prayed for by rendering a judgment. So court must also award interest. And interest, I got 3 types of interest. Interest which is past, number 2 current, number 3 what is called as future interest. In case of past interest, the word past means from date of loan till date of filing of suit. Current means date of suit till date of decree or judgment. Future means date of judgment till date of payment by the defendant of the amount of dues plus interest. So the court, while passing order decreeing suit of the plaintiff for recovery of amount of dues, should pass order regarding grant or otherwise of interest, past, present, and future. And failing which, the matter may be taken by the plaintiff to the higher court under appeal under section 96 of CPC. As regards interest, we got 2 sets of loans, commercial loans and loans for agriculture. So interest rate varies depending upon purpose of loan. Commercial loan, then banks charge interest at commercial rate, that is the normal lending rate of the banks. So 34 says if the suit is filed by the parties based on a commercial transaction, in that case, the point is future interest may exceed 6% per annum in case of a commercial loan, but the same may not exceed the contractual rate of interest. As per contract, the interest rate is 10%. Court can grant interest 6 plus above, but not exceeding 10%, even though as on date, the current lending rate by commercial banks for commercial loans is 15%. We cannot import now the present interest rate structure and fasten liability on the defendant at a higher level, since the contract says interest at 10% in case of the commercial loan involved in the case. And if the contract is silent regarding payment of interest, and the lender and X, Y is the borrower, and Y comes to me and request for loan of rupees 2 lakhs urgently, and I just give the amount of loan of 2 lakhs by means of a check. I don't take any agreement also. He encashes check. So without any agreement, I can go to court. I can show the court that I lent to Y, the borrower, 2 lakhs on given date. I can take copy of check from the bank. I can take from bank account extract. I can produce my passbook, and I can file a suit for recovery. My claim is 2 lakhs plus interest at 15% from date of loan till date of filing of suit, and thereafter at a given rate. So if no interest is fixed by the parties as per agreement, or if loan is given by means of a check to the particular borrower, then court can award interest on such suit, on such plaint also, on the point that court can award interest chargeable by commercial banks on commercial loans if there is no contract for payment of interest as per the agreement. So in case of check being given by the lender to the borrower Y by means of a check, there is no contract to pay interest, and the plaintiff cannot lead oral evidence and say that yes, he had assured that he will pay me interest at so-and-so rate, but court will not hear oral evidence of the party. Court says, produce document. The court says, you have to produce before the court a document containing term of payment of interest at a given rate. So court to award interest on loans advanced by nationalized banks for commercial transactions. So this point, advocates for the plaintiff must stress in the arguments touching 34 of CPC. So advocate must be empowered. You must not just guide the client. Interest is not sought for by you as per the agreement, and check makes no mention of interest. And we're not writing check all these things also, because that is what is called an addition to a check, and banker will not make payment. So the point is, if interest is not fixed as per contract, court can award interest at
It's 5 o'clock.
such rate as is charged by commercial banks on commercial transactions. If in a given case, court does not pass order regarding payment of future interest from date of suit, date of decree till date of payment, what about the effect of that particular decree? Court awards interest, past interest. Courts award current interest till date of filing, till date of the decree, but court does not pass order regarding payment of future interest from date of judgment till date of payment by the defendant. What about the effect of this particular judgment of the court? 34 says, if court has not granted future interest, but allowed only past interest and current interest, it is deemed that the court has refused to grant future interest from date of decree to date of payment. It is deemed that future interest is denied or is refused or is not granted by the court. We cannot import the point that if there is no order regarding payment of future interest and still the court grants interest past and present, we cannot presume that the court has granted future interest. On the same point, we have got Arbitration Consideration Act. There the law is different. If the award does not state regarding interest from date of award, the law presumes that interest at 18% per annum is awarded by the arbitrator or by the arbitral tribunal under provisions of Arbitration Conciliation Act. So in many cases, advocate for respondent will be very happy in an arbitration suit for recovery of 100 crores. We have filed there before the arbitrators. And arbitrator, sometimes they don't pass order. Interest being future from date of award till payment. Then the claimant, the decree holder in that matter of arbitration suit matter can recover interest future at 18% from date of award till payment. And defendant, the JD cannot say in the court that he will not pay the amount because statute, special statute provides that in case the award is silent regarding grant of interest being future from date of award till payment, the plaintiff can get, is entitled to interest at 18% per annum. There are all the nicer points which we can think of and tell to the judges only if we are defined. And with this, the next point is 35. 35 deals with cost. I file suit for recovery of 5 lakhs. I pay court fee of say rupees. I pay a court fee. X amount is court fee. Suit is filed by paying X amount of court fee. I told court should grant interest. The third point is, what about payment of court fee component X in the decree of the court? Can court refuse to award cost incurred by the plaintiff, paid as court fee on the plaintiff, paid to counsel as advocate's fees, and spent by the plaintiff for witness summons to the witnesses for the plaintiff, as the case may be? Here the point is, 35 Act, the Act says court has to pass order awarding cost in the suit to be paid by the defendant. The saying, the legal adage states that cost always follows the decree. And if the court wants to disallow cost, the court must give reasons why it wants to disallow cost to be paid to the plaintiff by the defendant. So 35 says normally cost should follow the event, cost should follow the decree of the suit, and court must give reasons if it wants to disallow cost incurred by the plaintiff to file the suit for recovery of the amount of dues. Then section 38 speaks of execution of the decree by the court. Court holds different, you pay 5 lakhs, different you pay interest, past, present and future. It says you also pay cost. And cases filed say 3 years or 4 years ago, today the court passes decree, passes the judgment. The sum total will be say 5 lakhs is the principal amount, interest cost will be around 3 lakhs. And as you all know, commercial loans after 6-7 years, loan amount will become double. I take loan of 10 lakhs in 2012. within 7-8 years, the loan amount becomes double because I don't pay any amount. That's not called as law of Dam Dupat. Dam Dupat is Hindu law concept. Here, over a period of time, I don't pay any amount. Interest will mount, and for interest, banker will charge compound interest. So within 7 years or less than 7 years, loan amount doubles. So 5 lakhs is the amount of loan. After 8 years, it will become 10 lakhs. So how to recover amount of decree? By executing the same before the court of execution. So civil court also works as a court of execution. It is not good if the court says decree is there, you keep in your pocket. The plaintiff wants money, and we have got the courts which pass decree, and they are given power to execute the decree and recover the amount of decree from the defendant. He is called as judgment debtor. Plaintiff here is called as decree holder. Decree holder for plaint, a decree holder for the petition for execution, and plaintiff for the plaint filed by the plaintiff. So 38 speaks of execution of decree by court which passed decree. Here, sometimes some problems may arise. I stay at Bangalore. Different stays at New Delhi. Contract was made at Bangalore. Different has got property at New Delhi. So, whether the court at Bangalore can execute the decree passed by it at Bangalore or not? Can court at Bangalore bring for sale the site of the defendant or JD at New Delhi, Karol Bagh, etc., as the case may be? So, court at Bangalore has no power to attach and bring for sale properties immovable of the JD which is situated outside the limits of the court at Bangalore. So this decree must be got transferred to the civil court at New Delhi for execution by filing a petition for issuance of decree transfer certificate under section 39 under section 40 of CPC. 40 speaks of issuance of decree transfer certificate, short form is DTC. We write in the body of order, which is DTC as paid for. Decree transfer to the court at New Delhi for execution. So 40 speaks of DTC to some other state for execution. 38 speaks of decree executed by the same court. Borrower stays at Bangalore. The JD stays at Bangalore. Property of the JD is at Bangalore. Court can bring for sale the property of the JD at Bangalore and auction the same and recover the amount of dues. So 39 of the Act speaks of transfer of decree to some other court within our state of Karnataka. So decree of Bangalore, the reference stays say at Dharwad or Gulbarga. Then they take the court order to transfer decree to the court at Dharwad or court at Gulbarga, civil court at Gulbarga, to execute decree if it is a case of attachment and sale of properties being immovable. If the borrower is employed, then you can get attached his pay or salary. For that, there is no need to transfer decree. Only for properties being immovable, we have to seek for transfer of decree to the court which is competent to try the competent to execute the decree. So 38, 39, 40 I've discussed. The next point is 41 of the CPC. Very, very important. Court at Bangalore sends decree to civil court at Delhi for execution. Court at New Delhi sells the flat of the borrower at New Delhi, recovers the amount, pays it to the decree holder. who has come to New Delhi. What law says? The transferee court at Delhi shall report the recovery of the amount of decree or otherwise to the court which transferred decree. So transferee court means court at New Delhi. Transferee court means court at Dharwad or Gulbarga, as the case may be, in our state. So those courts have got the duty to report back to the transferor court, Bangalore court, reporting recovery of the amount of dues or otherwise not recovered. And if it is informed to the court at Bangalore, the transferor court, it will make entry in the register called as register of execution. Because if the transferee court does not report, what happens? The court at Bangalore will still feel that that decree is not yet executed by the transferee court. So 41 of the Act speaks of the report by the transferee court of the execution of decree by it by sending a report to the transferor court. And if it is amount is fully recovered, that's called as the court must enter full satisfaction of the decree. In law courts, we call it as EFS. EFS means enter full satisfaction. So in the body of the order sheet, a judge will write EFS, amount is paid in full, file is closed. So this order also will be noted by the court solicitor in the register of execution if it is passed by the same court, and the transferee court shall inform to the transferee court the report of execution or not, so that it will make the requisite entry in the records. The next point is precept, section 46 of CPC. Precept, what it means. Today the court passes order. The JD stays at New Delhi. Advocate of the defendant sends WhatsApp message. Today's would decree. You would take steps to see that to sell your flat at New Delhi within 3 months. What happens? And now I got these WhatsApp messages. Within 2 seconds, we can transmit the court's order to our client. Today, say in the morning, Supreme Court of India, Quota number 1, came heavily on the central government. 47th day of burn and strike by farmers across the country. Still, you're not solving the problems. You say that you had 15 sittings. What is this? They just came very heavily on the Supreme Court of India. That news came very heavily. That truth news came very fast through WhatsApp messages on the channel. And the matter was there till up to 1:30. I had switched on the TV also. So my point is, we are now in a state of technology. The moment the court passes order, within a second, I will know it. And this man, the JD, takes steps to sell the property. And we all know that due to pandemic, we cannot find buyers very fast because finance structure has come down to all, earners, and even to buy also, people must think that we'll still wait, it will still come down, But the point is, we cannot just keep quiet, saying that nobody will go forward to sell it. And this JD is a person who is notorious. Means he had cases at Bangalore of loan taken by him from various persons at Bangalore, and they had got experience. The point is how the court can safeguard the fruits of decree from date of decree until this man, the decree holder, files before the court at New Delhi, petition to execute decree under Order 21, Rule 11 of the CPC. So any decree passed by the Bangalore Civil Court, appeal to High Court is 90 days. Up to 90 days, I cannot execute decree. The DH, decree holder, cannot say, sir, today decree is passed, tomorrow you file a petition to execute. We cannot file. If I file means, then I am not a mature advocate. Office will not take the file. They say, you wait for 90 days, then come. And even though you file after 90 days, we'll take it. We'll see whether we got from High Court stay of the decree or not. So here the point is precept. Precept means, in brief, order of the court requesting the other court which executes decree to attach property of the JD until this decree holder files petition to execute decree in due course of time. So it is a request by way of order made by one court to the transferee court to which the decree is taken for execution, requesting it to attach the property of the JD or the borrower or defendant as an interim measure. So until the decree holder files before the other court at New Delhi petition to execute decree, this precept will have its force. So the court which passed order will issue precept to the other court which executes decree, maybe other courts in our state, other courts beyond our state, as the case may be, asking it you attach as an interim measure the properties of the JD. And this precept issued by the court will be valid only for 2 months from the date of order. As we all know, the time limit to execute the decree is 12 long years. Time to file the suit for recoveries up to within a period of 3 years. So up to 12 years I can stretch. I can take decree, keep quiet, tap the door of the court at the end of the 11th year. But here precept says it is valid only for 2 months. Unless you again move the court, get it renewed for further 2 months. So that is a rider on the decree holder. Be alert. Take fast the decree to the court at New Delhi once the appeal time is over. So in this case, for time of 3 months, we can get 2 precepts. So 4 months will elapse. Within 4 months, must go to New Delhi, file petition to execute decree, and because of precept, the public interest is already attached. You can ask the court to make it absolute and bring for sale the property attached. So request made by the transferee court by a court which passed decree requesting that to your court will send the decree for execution, asking the court, and in this case the property is attached as an interim measure, that is 46 of the CPC. Precept means court to which decree is sent for execution. Then there the point is property of the JD will be attached as an interim measure until the amount is recovered. To see that fruits of decree are not being denied to the plaintiff. Plaintiff gives loan, plaintiff spends money, plaintiff he pays court fee, everything is there. But if by the time he executes decree, the property is sold, then the point is precept can be made use of by the plaintiff after the decree is passed. Then comes section 75 of CPC, read with order 26 of the CPC, what is called as commission. The plaintiff is not well, plaintiff is bedridden, suit is filed for recovery of 1 crore. What court can do? So the court can permit advocate to go to house of the plaintiff who is ill, record his evidence on commission, and come back. So advocate for both sides, they go to the house of the party. Advocate will record the evidence of the witness, Advocate for plaintiff will lead evidence. Advocate for defendant will cross-examine the witness, PW1. So that is commission. So if the party is not well, plaintiff or defendant as the case may be, then the court may issue commission to the court commissioner directing to do a given thing. Then comes what's called as suit by a party against government. Government is the borrower, lender is the plaintiff, recovery is of the amount of dues. Government gives bond, saying that will give the amount of bond after a fixed period of time. And for example, state government defers to make payment of the amount of dues. State government will always make payment, that's sure. So, an example, don't misquote me. Don't misquote me for any purpose, just for you to follow. Because here I got many law college students who are also logging in. So, suit against government or suit by government. Government is the lender, borrower is a third party. So, then what you invoke section 79 of CPC. 79 of CPC speaks of suits by or against government. So, section is 79, 80, 81, 82 of the CPC. Then the next point is, in case of a firm who can file suit under provisions of Indian Partnership Act of 1932, every partner is said to be an agent of the firm. A partner can file a suit for the firm against the defendant for recovery of the amount of dues. So if the deed has stipulated so and such person to file suit, he can file, failing which any partner can file suit against the defendant borrower for recovery of the amount of dues. That is provisions of Indian Partnership Act. Then suits by a company for recovery of amount of dues. So also company can sue or can be sued under Order 29 of CPC. So company can file a suit through its secretary, through its director, as the case may be. So there must be giving of power by the company to an officer to file suit for recovery of the amount of dues. So order is, the section is, the relevant provision is Companies Act and Indian Partnership Act. Next point is decree of a court is available to the higher court. It may be the district court, or it may be the high court, or it may be Supreme Court of India also. So appeal to the first appellate court is section is 96 of the CPC. Appeal to high court is 100 of CPC. Appeal to Supreme Court of India is section 109 of the CPC. Then comes what's called as section 121 of the CPC. Rules as per the code, they form part of the CPC. So section 121 says that rules in the first schedule, they form part of the CPC. That is the aspect of section 121 of the Act. And the law states that they are as if enacted in the body of code only. We cannot say, law says part 1, part 2. Part 2 is also a part 1 of the main code. Then the section is 137 of the CPC, 137. Language of the, what is the court language? So at Punjab, court language is something else. In our state, it is Kannada. In Maharashtra, it is Marathi. So court language is the regional language which is notified by the state government. But my point is, even though the court language is Kannada in our state, we cannot say that judges of the trial courts at Bangalore or in our state should not transact in English. So Kannada they can transact or they can work, they can record evidence. So language of court is as determined by the state government. That is the aspect of the CPC. Then comes section 151 of CPC, 151 CPC. So last day we dealt with this aspect. So section 151 CPC is very, very important. saving of power of the court. That is called as the court has got powers, even though the statute does not confer. So that is also the powers of the court. Say in given case, the plaintiff wants time to pay payment of court fee. He files suit by paying court fee of only 1 rupee. He can file. Section is 149 of CPC. I have no funds today to file suit or to pay court fee of 2 lakhs. I can just say the court, I want time of 1 month. And allow me to give time of 1 month to pay court fee. I can file suit on payment of only 1 rupee court fee. So the court can extend time by 2 more months after expiry of 1 month time granted by invoking section 151 CPC. Then lastly, section is 153 capital B of CPC, place of trial to be deemed to be open court. So the place where the court functions to try a civil case, we call it as open court. Public have got access. So that is section 153 capital B of the CPC. Whereas a petition filed before the arbitrator for recovery of 100 crores, as per agreement, the arbitral tribunal is not an open court. Only the party or parties and their counsel, they only can be in the hall where the arbitrator records evidence, takes the case or proceedings, because that is by God separate procedure. And the arbitral tribunal is not called as open court under section 153B of CPC, whereas a regular civil court is called as open court. Public can access, public can go, but Municipal Mallikarjun can go there and see how his student, who is now advocate, is doing in the court. So I can go, everybody can go, as long as we don't make mischief, as long as we switch off our mobile and maintain court's decorum, court will not ask us to go out. Whereas in case of criminal trials, this right is not absolute. Regarding criminal trials, sexual offences case is going on. Trial of sexual offences, court holds proceedings in camera, but not in open court. I'm saying by the way, don't mistake me. So criminal trial, that's also trial in open court. In some cases, say domestic violence case matters, sexual offences matters, offense of rape with murder, offense of sexual, offences, then the proceedings shall be held in camera. So only the judge, counsel for the accused, the prosecutor, minimum court staff, advocate for advocate for accused, they only will be in the court hall. Juniors of so and so cannot come. Law college students to see it, they cannot come. That is the aspect of criminal trial. With this, the second important lap is the first schedule 2, the CPC. Then order 1 speaks of what are the parties to whom, against whom are to file suit. For money suit, the plaintiff is the borrower, the plaintiff is the lender, and the defendant is the borrower. Borrower dies, implead, bring on record the legal heirs of the defendant. So on the date you file the suit, the borrower dies. File suit against the legal heirs of the borrower. That is order 1 of the CPC. Then order 2 is a frame of suit. So suit you have to file as per the format. We have got what to be added, what to be stated. It's called a frame of suit. Order 3 is advocate for the plaintiff can file suit, or plaintiff can file suit in person also. 3 is appointment of advocates, appointment of pleaders by the parties to defend their interest by plaintiff or defendant. Order 4 is filing of suits by a plaintiff. I told file suit along with the plaintiff, order 4. Order 5 is summons to the defendant. So the court You approach, file a suit, court will send you summons to the defendant under Order 5 of the CPC. Defendant avoids to receive summons. Defendant pays tips to the process server. We don't know. I mean, example. And the process server gives report, door locked. He sends it by RPAD. There also he managed to see that it's not served. Then lastly, take the summons by means of a paper publication under Order 5, Rule 20 of the CPC. Or ask the court to affix the summons on the door of house of the borrower or the defendant. So we got their set of rules, very big order, Order 5. Then Order 6 is pleading. What's called as pleading? Pleading is either plaint or WS. Advocates confused. Advocates say pleading means both WS and plaint. Pleading is plaint or WS. And the plaintiff, I file a plaint, that's called as pleading. Defendant files WS, that's called as pleading. And for the court, pleadings means plaint and WS, because on those pleadings, the court frames issues, points of conflict, points of controversy. So pleading and pleadings, plaint and WS, and Order 6 says what must state in the plaint, contents of plaint. So what to be stated, form of pleadings, then what about the aspect of particulars which are to state. So in Order 6, they state how to draft a plaint, what it must contain, then pleading to be signed by the parties, plaintiff to sign or fix left thumb mark, then it must be verified, and there must be affidavit of the plaintiff saying that what I stated is true and correct to the best of my knowledge, belief, and information. Then comes Order 6 Rule 7 of CPC. Rule is 17 of the CPC, amendment of pleadings. I want to amend the plaint. Through oversight, I paid for rupees 2 lakhs in place of rupees 3 lakhs. I can move the court to amend the plaint by filing application, and the court in fit cases will allow the plaint to be amended. Then comes Order 7 of the CPC, that is plaint. So plaint is the statement in writing filed by the plaintiff before the court, setting forth cause of action, setting forth the particulars, and setting forth court's jurisdiction, and also making prayers for which he has filed the suit. So Order 7 Rule 2 states that in money suits, 7 Rule 2 speaks only of money suits. The money suits state in clear words amount of claim for which one decree. And you must also state approximately the amount, if the amount is not certain. Say, in case of mean profits, we cannot fix now only the amount of mean profits. The court, you can state only amount which is approximate. So, and state who is liable to pay the amount, whether first defendant or second defendant, liability of defendant or which defendant is to state. Lastly, state specifically relief claimed. So, by mistake, we don't claim interest. Court passes your decree as paid for. Then, for your mistake, there is non-grant of interest by the court. My point is, state distinctly, state properly the relief claimed, amount of so and so, past interest so and so, current interest current so and so, interest with so and so, state properly the relief claimed in the prayer column of the plaint. 8 is WS of the defendant. So, as per the amendment 2, the CPC would file WS within 120 days from the date of receipt of summons of the suit by the defendant. Formerly, courts were liberal, they were giving dates, and now the final point is the limit is outer limit of 120 days from date of service of suit summons on the defendant. And the court, in fit cases, can extend delay beyond the limit of 120 days if there is proper cause shown by the defendant. But in case of commercial disputes governed by commercial courts under Commercial Courts Act of 2015, court has no power at all to extend time beyond the limit of 120 days. This is very, very, very important. Advocates who are practicing on civil side, many a times this point they will miss. In case of commercial suits filed by the plaintiff before a commercial court or a provisions of Commercial Courts Act enacted 5 years ago, the ruling of Supreme Court of India states, you must file WS within 120 days, failing which court has no power at all to extend time and take from the different WS file after the 121st day. So that is departure from the general civil law compared to the Amendment 2, A or 8 of the CPC, only for the commercial courts, because commercial courts have got fast track procedure. See, businessmen of foreign countries, they want to come to India to make business. And if they are just asked to wait for 10 years to file WS, what happens? See, in a case of Bombay High Court, delay of 5 years was condoned by Bombay High Court to file WS. In one more counter case of the same party, delay of 12 years was condoned by the High Court of Bombay. And the matter went to the single judge. He wrote it, extended time. High Court of Bombay, appeal was filed by the plaintiff. High Court confirmed order of the single judge. Plaintiff went to Supreme Court of India. Supreme Court of India told, in case of commercial disputes, courts cannot grant time beyond the limit of 120 days. If it grants, that's a nullity. It's a wrong order. So my point is that is a separate topic, but I'm just saying by the by. And with this, so 8 is WS and set off and counterclaim. Different may say, yes, sir, I have to pay to plaintiff 2 lakhs, and plaintiff has to pay to me 1 lakh. I will pay only the amount of balance of 1 lakh. You may seek set off, or you may seek counterclaim. You may say that I'm not liable. On the contrary, I had gone check for 8 lakhs. That amount he has not paid back to me. You may seek for counterclaim the very suit of the plaintiff by filing court fee, and counterclaim is called as a suit by defendant on the plaintiff in the same particular suit OS itself. So WS by defendant set off can be claimed, and he can also file his counterclaim as a suit in the same suit under Order 8, Rule 6 of the CPC. Must pay court fee on the counterclaim. Then court goes to stage 2, the plaintiff to file WS for counterclaim of the defendant. Then comes 9 of the CPC, appearance of the parties. Summons are served by the court on the defendant, Order 5. Then court says on a given day you appear. 9 speaks of appearance of the defendant before the court. So he has to appear, file his WS, take date as the case may be. So 9 is with regard to parties' appearance. 12 is admission. Defendant states, sir, I have to pay the amount. I'll pay the amount. That's called as admission. Court can pass judgment on admissions only under Order 12 of the CPC. Advocate must be well read. Advocate must be sharp. If he reads WS, he says that there is admission. He can ask the court, invokes sir, 12 of CPC, file IA under 12 of CPC, 12 of CPC. Court can pass judgment forthwith. Judgment on admission. And order is 13 of the CPC, 13. That is, parties can produce documents on date of hearing or on date fixed by the court to produce the documents. Then 14 is courts to frame issues on points in controversy. Court reads my plaint, court reads my WS, they read what is my objections, my attack or defense. On point of conflict, they frame issues. Issues are of two types: issue of fact, issue of law. Issue of law, the court must decide at first. Issue of fact to be postponed. If an issue of law only, court can pass main order. The suit goes. The suit is disposed of. So issue of fact, issue of law, as the case may be. Then comes Order 17 of the CPC. So Order 17 of CPC deals with adjournments. When the plaintiff or defendant can move the court for adjournment by court rules. Then Order 18 is how to examine parties, who has to lead his evidence. Under Order 18, Rule 1, plaintiff has got the right to begin the suit. So here, the plaintiff has got the right to begin the suit, and that is the prerogative of the plaintiff. Our law college students may ask the question, when, sir, the defendant can move the court and say that I will first lead the evidence, thereafter let the plaintiff start his case. Can court put the horse back and permit the defendant to lead evidence first, and thereafter permit the plaintiff to file his affidavit and lead evidence? The question is tricky, and the answer also is tricky. And this question, if asked by our great friend, our actor Amitabh in his Kaunbrega Crorepati, yes, he means money for one show, for one particular show, he means money. He may ask it as the 15th question, 1 crore, whether the defendant in a given suit can pay the court and request the court to permit him first to lead evidence and then permit the plaintiff to lead evidence. And here the answer is, as you all know, the court in fit cases can permit the defendant to lead evidence first and then call upon the plaintiff to lead evidence if it is for some definite purposes. Plaintiff is going abroad for 2 years. Plaintiff says, I'm here now, sir. I'll be here for 1 more month. He says, let court record my evidence. I'm the defendant. Let the advocate for plaintiff cross-examine me. I will go to USA. I am there for 2 years. And let the plaintiff start his case. My counsel will take care of the case. So in that case, court can permit the defendant to start at first his evidence and then after record evidence of the plaintiff. So there's provision in which court can accommodate that defendant. Or if the defendant is extremely unwell, he is ill, he is counting days, advocate for the defendant may say, sir, permit me to examine the defendant now only. Court can permit. So that is Order 18, Rule 1, 18, Rule 4 of CPC. Then Order 20 is judgment and decree. I have spoken to. 21 is how to execute decree. That Order 21 has got 106 rules, biggest order containing largest number of orders, rules in Order 21 of CPC. Then 22 is death of the parties. The defendant dies or plaintiff dies, what court can do? So court can bring about legal heirs of the plaintiff or defendant, legal heirs of the decree holder or GD as the case may be. Order 23 is compromise of suit, or the defendant makes payment to the plaintiff, then there must be the suit be withdrawn by the plaintiff, withdrawal of suit or compromise suit by the parties. Then nextly, what's called as suit by persons who are indigent, persons who cannot pay court fee. They are called in the court words as pauper suits. Pauper suits means the person who has no money to pay court fee for recovery of a given amount of dues or to file a suit. So here, sued by a person who is not able to pay fees is called as indigent. You can file suit and file application under Order 33 of the CPC, praying for exemption of payment of court fee. Then comes Order 37, summary procedure, summary suits, or take at the end. 38 is arrest and attachment of property of the borrower or JD. 38 Rule 5 is attachment or judgment of the property of the defendant when the suit is still pending, and a small cause court has no power to attach property which is immovable of the defendant or the JD under Order 38, Rule 13 of the CPC. Then Order 41 is appeal to the appellate courts against decrees of the trial courts or the first appellate court or second appellate court. So 41 is appeals to the appellate courts. Then Order 47 is review of judgment or order. So with this, I completed the aspect of the CPC, and we have got Appendix A to CPC. Plaint is as per form number 1, they have got format of plaint, and for pleadings we have got a separate format. Form 4 is defense or double-S of the defendant in suit for recovery of money. So double-S, how to file, what to be contained. We have got form or format number 4, defense or double-S in the suit filed by the plaintiff. So with this, the second important aspect is namely summary suit, summary proceedings, or summary procedure as it is called. So summary suit or summary proceedings or summary procedure. Order is 37 of the CPC. So Order 37 of CPC speaks of summary suit or summary proceedings or cases involving summary procedure. So this Order 37 deals with various important things. Summary suits can be invoked only for recovery of amount of dues and not in any other case. So the important point is recovery of suit is there. We have got option to invoke the provisions of the summary suit also, or file a regular suit, as a small cause suit, or a regular ordinance suit, as the case may be, before the civil court or small cause court, as the case may be. And summary suit means only before the civil court only, but not before the small cause court. So the summary procedure applies to high courts, applies to civil courts, applies to what's called as courts of small causes and other courts in the country, and that applies to suits based on bill of exchange, suit based on promissory note, suit based on hundis, suit for recovery of debt. So money suit you can file also by way of a summary suit. You may ask, sir, what's the benefit of summary suit, sir? Same court fee you have to pay, but here there is fast track procedure. Time for disposal is shortened, and defense and referent is also not much here. So suit for recovery of money can be filed as a summary suit before the civil court at a given place based on contract in writing or based on a guarantee. That is the aspect of rights of the plaintiff to file suit for recovery of the amount of dues as a summary suit only. The next point is what file here plaint, and we have to also, along with plaint, enclose what's called as summons of suit under form number 4. So plaintiff for the summons suit, summons plaint has enclosed what's called as summons suit to defendant by means of form number 4. You must give with the plaint what's called summons of suit to defendant under form number 4. of Appendix B, and defendant on service of the summons under form number 4 has to appear, and if the defendant fails to appear on receipt of summons of suit under form number 4, then it is deemed that the defendant has admitted the claim of the plaintiff. So see how it is very tricky. Suit is filed by the plaintiff as a summary suit. He files with the plaintiff summons of suit to defendant under form number 4. Defendant takes the summons and defendant defers to appear on date fixed. The Act says it is deemed that the defendant has admitted the suit of the plaintiff. And as per Order 37, Rule 2, the plaintiff shall get decree as paid for. Summons are served, summary suit. Plaintiff serves on the defendant what's called as summons of suit under form number 4. Defendant takes summons, keeps quiet, defers, plays ex parte, then it means that the defendant has admitted the claim of the plaintiff. The court shall pass decree as paid for if the defendant on receipt of the summons of suit as per form number 4 defers to appear. So I told advocates, and sometimes if they don't appear on a given day for a summary suit, it may be a fatal thing for the defendant. For general suits, we can invoke the court, set aside ex parte order, sir. But here, law says plaintiff shall get decree for claim amount and cost and interest up to the date of decree. That is mandatory. The plaintiff shall get decree for the amount of claim, amount of cost, interest also up to date of decree. That is Rule 2 of Order XXXVII CPC. What about procedure? Defendant takes summons, comes to court, appears. Can court grant date to the defendant to file WS? Here we got a rider. Defendant appears before the court. Plaintiff shall serve on defendant what is called as summons for judgment, saying that amount of claim is so and so. He shall serve on the defendant a summons for he must serve on the defendant summons with annexures, and within 10 days from service of the summons along with documents, defendant shall appear before the court through counsel or in person, and if the defendant appears, the plaintiff shall serve on the defendant what's called as summons for judgment under form number 4 capital A as per Appendix B, and within 10 days thereafter the defendant shall apply to court seeking for leave to defend the case, and if leave is not sought for by the defendant, then the court can go forward. So defendant appears, the plaintiff shall serve on him annexures, then 10 days time is given, he has to file his defense, then he must be served with what's called as summons for judgment under form number 4A. Then the defendant within 10 days of service of summons for judgment disclose his defense, and if the defense shown by the defendant is proper and legal and lawful, the court can grant defendant leave to defend the case and file WS. If the defendant cannot show to the court proper grounds to defend, or if the grounds urged are false or mischievous or concocted, then the court may refuse to grant to the defendant the leave to defend. So he has to apply for leave to defend within 10 days from appearance, and if there is no proper defense, then court can refuse. If he has shown some defense, then the court can permit him to file the place. Or if he admits part amount to be due and payable, court can ask him pay first the amount you admit, and for the amount of balance, will give it time to file your WS. So this is the thing as per the summary trial. So duty of the defendant to file WS is not mechanical. He must seek the court's leave to defend the suit, and if the defense is not proper and just, court can refuse, and court can go forward and pass order. And if the grounds are proper and sufficient and reasonable, then the court can, in this case, permit the plaintiff to what's called as grant time to the defendant. Sorry. So that is the version of the summary trial. The next point is amount admitted. He shall pay the amount in court. That is mandatory. He cannot bypass that particular thing. And if the defendant has not sought the leave of the court to defend the case, or does not pay the amount admitted with the court orders him to pay, then the plaintiff shall get judgment as prayed for. That is Order 37, Rule 3 of the CPC. This is a very technical order, technical subject, and advocates and judges must read this Order 37 not one time, many times, and they must get support from the case laws of the Supreme Court of India. And if the defendant is permitted by the court to file his defense, then the case goes forward, failing which the plaintiff shall get judgment forthwith if the court refuses to grant time to the defendant to file WS. So with this, I completed the aspect of a trial of suit in a summary manner called a summons suit. And here I will just tell you case laws of Supreme Court of India, because one decision is overruled in 2018. And we know some advocates, they are very clever to quote before the court. Decisions overruled, decisions which are not good law on the point. I'm not commenting on account of lack of knowledge or sometimes to mislead also. So the case is 2018 SCC online Supreme Court, page number 2795, IDBI Trusteeship Services Limited versus Hubtown Limited. Justice R.F. Nariman penned down the judgment in the case of 2018, a case of authority on the principles which court must follow while hearing suit based on summary trial procedure. So 2018 SCC online Supreme Court, page number 2795. The case is IDBI Trusteeship Services Limited versus Hubtown Limited. In this case, the apex court held that summary suit is filed by the plaintiff on, in this case, the suit was filed by the plaintiff on what's called as corporate guarantee.
It's 6 o'clock.
By a company. So summary suit was filed by the plaintiff on corporate guarantee. And Supreme Court in this case superseded its earlier decision in the case of mechanic engineers and manufacturers versus basic equipment corporation. That is 1976 part 4 SCC page number 687, by saying that ratio in that case on summary suit is not good law. Supreme Court superseded the ratio in the case of mechanic engineers and management versus management and manufacturers versus basic equipment corporation. that is 1976, Part 4, SCC, page number 687. So it told it's not good law. And the good law is in the case of Milky Ram, India versus Chamanlal Brothers, AIR 1965, Supreme Court 1698. A copy of judgment of Supreme Court of 2018, if you take it, you know one case is overruled and old case of 1965 is set as good law. And here, Apex Court has given us 6 principles which we must keep in mind while disposing of a suit based on summary trial. The first principle is, namely, if defendant shows to court that he has a defense to go forward, and the defense is proper, defense is plausible, and court feels that the defense is not a false defense, then the plaintiff shall not serve on defendant summons for judgment. Defendant files WS, defendant says to court, I have got defense. He says, I have paid the amount, sir. Why you want me to again pay the amount? He shows the records. So defense is proper. Court must permit defendant to file his defense or WS. That is the first ground. So if defendant satisfies the court that he has a substantial defense to make to attack the case of plaintiff, then plaintiff is not entitled to sign or furnish to the defendant what's called as summons for judgment. And the defendant shall be given the leave to defend. First principle. Second point is, if defendant raises a tribal issue, first one, full defense, proper, pakka. Second one, he raises a tribal issue. He says, I will prove, sir, give me time. He raises a tribal issue and has got a fair chance of success in the defense. Then, though not a positive defense or a good defense in the full set of percentage, then plaintiff shall not serve on defendant summons for judgment, and the court shall grant to the defendant leave unconditionally. So second point, case is a tribal case, then court can grant him time, say that you file your WS. So the court may give to the defendant leave to appear. The third point is, defendant appears, raises tribal issue, and here court has got a doubt. This issue is raised up just to avoid the claim. Court can know the trend of the advocate for the defendant by seeing the records. Court can know the mind of a advocate the moment he enters the court hall. See, we have worked in courts. Within 3 months, we know who is who. Which advocate is ready always, which advocate takes state, which advocate quarrels, which advocate cooperates, but we don't find fault. We do our duty. And we are there to do duty and work as per justice. So if defendant raises a tribal issue, that has got a doubt that the issue is really genuine, and the court feels that there is no good faith on the part of the defendant in making that plea. But that cannot say now only, because he has got some, what you call, opinion now, not formed based on evidence. Then what the court can do, in this case, the court can impose conditions. Yes, I will grant time. Within this time you file WS. You must be very fast with the court to go forward. So if defendant raises issue which is tribal, and court has got doubt in his mind that the issue is not genuine or lacks good faith, then the court can impose condition regarding mode of payment, time of trial, and can say, you pay now half lakh, pay remaining half lakh after decree. Court can pass an order like this. That is the third important aspect. The fourth point is, defendant raises a plausible defense, but it is not, but it is not probable. Court feels that this defense will not work out, but he has made some defense. That's called as a defense which is plausible. Then court can impose conditions. Okay, you have made your submission, you're advocate, you're a junior, I will give time. Okay, you go forward, file WS. Then court can give date to file WS on conditions, saying that you give due to the plaintiff security for rupees 1 lakh amount of claim. In case the case is decreed against you, you may run away. So the court may ask, in that case where the defense of the defendant is not probable, pay now the cost, pay now security, pay now some amount in court, then I will permit you can file WS. That is the fourth scenario. The fifth scenario is, namely, defendant has no substantial defense at all, or raises vexatious claims, or raises claims not being germane, false, frivolous, etc. Then the court shall refuse to grant leave. Defense of the defendant is nothing. He says, sir, I signed a blank check. He has filled it up. No court believes check is issued means for consideration. So the defense is not substantial. Defense is frivolous. Defense is false, based against the records, documentary evidence. Court shall refuse to grant to the defendant leave to defend. Then court shall pass decree as paid for. In case of a summary suit, fifth point is, defendant has no substantial defense and raises frivolous defense, vexatious defense, then court shall refuse to grant to defendant the leave. What happens? Plaintiff suit for recovery will get fast tracked. Immediately court passes judgment on the same day or next day. Then lastly, if defendant admits liability for part amount due by him, court says you pay now at first part amount you admit, then will give time to pay the amount of balance, you file the place for the amount of balance. That is the sixth set of scenario. So judgment of, which is Roington of 2018, that IDBI, that is the Hubtown, speaks of these six important parameters which are guiding factors for the courts, advocates, and for parties who contest the case in person. So summary suit is not that simple. For me also tough, and for teachers also difficult to teach this particular Order 37. Dr. Mallikarjun knows it, and Vikas also knows it, because in the High Court at Chandigarh, we may have seen so many cases, and these cases on point of technicality only, they are dismissed or they are allowed. And in my personal opinion, the best point is we can file simple plaint, take some more time, then go forward. But summary suit means advocate must be well read. He must be sharp. Judge may not know all the provisions. He must tell the judge, see, this is the important aspect, this is the case on the point, and he must guide the judge. And judges, many times, they hear arguments of the counsel for both sides at length. In Supreme Court of India, we have seen they appoint amicus curiae, not for fun. They say that we don't know about anything. We want so-and-so as amicus curiae. You assist us, you guide us, you give us inputs, we will go forward. Since that Bharat Bharat Stage 4 cases, Bharat Stage 4 vehicles which we had from 2010, now we got Bharat Stage 6 vehicles from last year. Supreme Court of India, in a bench headed by the then CJI, that is T.S. Thakur, and two others, they appointed amicus curiae, Counsel of Supreme Court of India, Senior Counsel, to assist the court and guide us regarding law regarding air pollution, law regarding environment, how to make use of vehicles at Delhi. See, they banned use of the buses driven by diesel, by use of diesel engines. Now they have got only battery powered engines, electric, buses. So that is the aspect of this work of amicus curiae, which court engages, court takes, because court can claim to be master of everything and knows everything. So I told you 6 case laws of the apex court, 6 important points of the apex court in the above case, and one more last case is Sudhin Dilip Talurikar versus Polycap Wires Private Limited. That is 2019, Part 7, SCC, page number 277. Sudhir Dilip Talurikar versus Polycap Wires Private Limited, 2019, Part 7, SCC 577. Here, para 11, it says, ultimate object of a summary suit is efficacious disposal of a commercial dispute. The purpose of a summary suit is disposal of suit very fast, efficaciously. That is the purpose. If defendant discloses a case of success by stating the proper defense, court may grant leave to him. If not, court can refuse and pass judgment forthwith. That is the latest law of Supreme Court of India of the previous year. So with this, I have completed the first 2 slots of the study. The third point is court fees. We got at Karnataka Court Fees and Suits Violation Act. Here, 21 of the Act speaks of court fee on money claimed. Pay court fee on the money claimed by you in the suit, in the plaint. Recovery of 1 crore, pay court fee as per tariff. Recovery of rupees 10,000, pay court fee as per tariff. So 21 is the section for payment of court fee, and Schedule 1 of the Act speaks of what is the amount of court fee payable by the plaintiff in a suit for recovery of the amount of dues. So we have got here a separate chart is there. The same chart is there for other states also. State of Maharashtra, Punjab and Haryana state, at Delhi, we have got separate schedule as per the state acts regarding court fee. So here in our state, recovery of any amount up to rupees 15,000, that is 2.5%. Suit for recovery of rupees 10 lakhs, the court fee is rupees 62,125. So the slab goes on increasing. For recovery of suit of rupees 1 crore, of rupees 80 lakhs, the court fee is 2.47 lakhs plus excess amount beyond rupees 80 lakhs at 0.5% on the remainder. So recovery of amount of rupees 80 lakhs, the court fee is 2,47,125. 247,125 recovery of payment of court fee for recovery of rupees 80 lakhs. The same case, if it goes to an arbitrator, before the arbitral tribunal, no court fee is there. You may ask, how, sir? Tell me. So I'll tell you now the aspect of how we can save court fee, how we can have fast track in this sphere of this area. Also, there is arbitration. That is the fourth topic is namely, the third topic is Arbitration and Conciliation Act. Section 2, subclause 1 of the Act speaks of arbitration. It means in arbitration, either domestic or international or permanent institution, as the case may be. 2(1)(b) speaks of agreement of arbitration. 7 speaks of what's called as agreement of arbitration. It states that parties to contract may agree beforehand, now only as per agreement, that for any dispute between the parties, we can approach not the regular civil court, we can approach the arbitrators, or we can invoke the provisions of the Arbitration and Conciliation Act. Say for a case of loan lent by X to Y of rupees 100 crores. Agreement says disputes of any type on the agreement, the parties can invoke the provisions of the Arbitration and Conciliation Act, and they can appoint arbitrator. So X can nominate his arbitrator, Y can nominate his arbitrator, then those who arbitrators will appoint the umpire, or they may appoint, or they may go to High Court, and High Court will appoint the arbitrator. So 7 speaks of agreement clause in the arbitration, which states that the dispute shall not go to civil court. Dispute shall go to the forum of arbitration governed by Arbitration and Conciliation Act. So here, in this case, any agreement having a clause of this type ousting the powers of the civil courts of a given place, then the parties may agree, saying that we will approach the forum of arbitration under the Arbitration Act, and that if that is the term of contract, then this matter cannot go to regular civil court. It cannot go to regular court for, recovery of the amount of dues. The case must go to the forum of the ADR only, arbitration, and parties can nominate the arbitrators. If they disagree, then the party can approach the High Court by petition under Section 11, subclause 6 of the Act. High Court appoints arbitrator, and we have got at Bangalore what's called as Center of Arbitration at the College of Honor, Bangalore. So there, the matters to the Center for Hearing by the Arbitrators, which the High Court appoints. Then for this particular case of recovery of 1 crore, filed by plaintiff, there is called as claimant before the arbitrator or the tribunal, there is no payment of court fee. So 2.87 lakhs for recovery of 80 lakhs in a suit filed by X against Y. If the agreement has no cause of arbitration, has to pay the court fee with the civil court and wait for years. For arbitration, if the agreement has got a clause, approach the forum of arbitration, then there is no court fee payable by the plaintiff, the claimant, for recovery of any amount. So this is the plus point of arbitration. Court fee is not there. Only fees to be paid to the arbitrators as per the tariff, as per the Act or the center, or the case may be. And here the point is, agreement has no cause of arbitration. Agreement says civil court. Then parties now can agree. Yes, we don't go to civil court. That takes time. Today I can agree. Say that disputes of any type, we will approach the forum of arbitration under the Arbitration Act. So now also I can make contract and say we are governed by the principles of arbitration, but not regular civil court tribal. So that is 7 of the Act. So we can save court fee. And one more time is time limit for the tribunal. So the time limit is to pass order within 12 months from the date of sending of the order of appointment of the arbitrator by the High Court or by the party or by the parties as the case may be. So within 12 months on the date on which I receive the order of appointment, I must pass order, I must pass award. I cannot keep it beyond 12 months. That's all. I have to give dates as per my requirement, see parties, and fix the calendar, prior to starting of the case. So that is 12 months outer limit. And in a fit case, I cannot do it within 6 months, within 12 months. Parties can agree to extend time by 6 more months. So at the end of the day, 1 year, 6 months is the final limit for the arbitrator to pass award in a suit which can be tried by the arbitrator. Suit for recovery of amount of dues is tried by the arbitrators if there is a clause saying that we approach the forum of arbitration. So we can save court fee, we can save time, we can get fast decree, there is a fast track procedure, and strict rules of CPC and evidence have no application. But court must follow the principles of CPC and principles of Evidence Act that is there, and that is the aspect of 7 of the CPC. And in a given suit, the court now knows. Suit filed by me before civil court contains cause of arbitration. I paid court fee of 2.75 lakhs. Defendant says, sir, there is cause of arbitration. Then court has to permit me to withdraw suit, refund court fee to me, approach the forum of arbitration. Time spent by civil court will be excluded to file the claim statement before the arbitrator. That is the 8 of the act. So with this, I will not take much of your time. And for plaint, we call here as statement of claim under section 23 of the Arbitration Concession Act. So plaint is called as statement of claim, and WS is called as statement of defense. Section is 23 of the Act, and 29 is speaks of award of the arbitrator within 12 months or within 18 months. And there is one more procedure. Within 6 months also, there can be award under section 29 capital B of the Arbitration and Concession Act. What is called as fast track procedure. Parties beforehand, before the arbitrator, on the first day states, sir, we don't need evidence. We'll only produce documentary evidence. Only documentary evidence and our arguments will pass the award. That's called as fast track procedure. So if the parties say that read only pleadings, only our records, our submissions, oral arguments, you can pass the award, then that's called as award on admission, oral admissions, admissions in writing, that is fast track procedure. And for this, the time limit is 6 months only from date on which I get from the party or from High Court what's called as order of appointment as the arbitrator. So there is the things with which advocates must be empowered, and they know it, but still reading and rereading will make us further sharp and further alert. And with this, the last point we touch is the Limitation Act. I think I haven't touched it. That is a very, very important aspect. What about time limit for the plaintiff to file a suit before the court? That is the Limitation Act of 1963. So that is the aspect of our important study. You may ask me a question: why the law is given to the decree holder time of 12 years to execute decree, and why a shorter period of time in case of right of the plaintiff to file a suit for recovery of the amount of dues? To get decree, fine. To get amount recovered, the time is 12 years from date of the decree of the civil court. So here the point is why the law has given to the decree holder more time to execute decree and less time to file suit. So the law of limitation 3 of Act states 3 says bar of limitation, suit filed beyond limitation is called as a time barred suit. Court cannot receive it. Court cannot give to it OS number. So 3 of Act says bar of limitation. So suit filed beyond the limitation period is a time barred suit. And time barred suit means there is no question of decree. Even the court will not receive it and assign to it a suit number. 3 is bar of limitation because it is a claim barred by time. Then section 3B, set off and counterclaim. I file suit within a given date in time. Defendant appears, files WS, files set off claim or sues for counterclaim. What about time limit for him to file his claim? So for set off and counterclaim, on the date he receives summons of the suit from the court, from that date, or the date he appears in the court, from the date he has to file his counterclaim. So set off or counterclaim shall be deemed to be a separate suit under even the law of limitation, and the time limit will start here from date of receipt of summons of the first suit by the defendant from the court. And the point is question of limitation, that is a question of jurisdiction, but not a question of fact. So no law can be laid down. This is the set of rules, which means question of limitation. So question of limitation is a question of jurisdiction. I say it's a it's a time bar suit, sir. So that goes to the court jurisdiction to hear the case. So limitation is a question of jurisdiction. That is Lachman Singh versus Hazara Singh, 2009, Part 5, SCC, page number 444. So limitation is a question of jurisdiction, and court must give a decision whether it has got the power to try the case, and if the court has no jurisdiction, the matter goes, the matter is dismissed. So Lachman Singh versus Hazara Singh is a case of authority on the aspect of limitation as a question of jurisdiction. Then 4 of Act is expiry of the time of limitation when the court is closed. See, the courts were closed last month because of vacation, because of Christmas vacation, courts were closed. So I can file suit on the date the court reopens. In Karnataka, the court reopened on 2nd. So suit getting time barred by end of last year. I can file suit on the court reopening day after its reopening, after the vacation being over. So filing of suit on a day, on the next day on which the court was closed. Suit gets time barred on Sunday. I can file suit on Monday. Invoke 4 of the Act. So, and now, as per the decision of Supreme Court of India, our High Court, because of COVID pandemic, suits getting time barred between March of last year till end of this month, 31/1/2021, we can file at the latest on or before 31/1/2021. So that is also 4 of the Act. A suit getting time barred between March last year and till end of January this year, we can file that suit even now also on or prior to 31/1 of this month, because Supreme Court of India, High Court has passed the order just 2 days ago. They have issued circular, they have issued notification. So that is 4 of the Act. They invoke 4 of the Act. So that is aspect of the law of limitation. 5 is extension of time on showing of sufficient ground by the plaintiff. Plaintiff says, sir, I was not well, sir. Plaintiff says, I was out of country. I came now, sir. There is a delay of only 3 months, condone delay. Can court condone delay in filing of suit or not? The question is, can court condone delay of 3 months because I was not well? I had heart attack. I came from abroad just today morning, sir. And he says, I was quarantined for 2 weeks. I came by British Airways, sir, and I could not meet an advocate. Can court extend time beyond the limit of prescribed time for recovery of money in a given suit, by the plaintiff? So there cannot be extension of time to file a suit beyond the lifetime of limitation. So suit shall be filed within the period of limitation. Only for appeals and petitions or applications, the court can condone delay if not filed within the time limit to file appeal or application, as the case may be. So for suits, file suits within the prescribed time, filling which you have to thank yourself. No advocate can guide you. Advice, bring sir, will file it. If he says means, then he is deceiving you. My point is, for suits, 5 of Act has no application at all. Then the next point is, what about legal disability? Plaintiff is a minor. Plaintiff is unsound. He has to file suit before the court for recovery. Plaintiff is now a man of unsound mind. He has idiocy. He is called as an idiot in law. So in jurisprudence, the word idiot means a person who has lost his complete sense of mind. So in houses, parents bang their children, you're an idiot. It means in law, a person who has lost all his senses, not even half also, he is fully gone. So here, bar of disability. I am disabled now to file suit. I am mentally ill now. I am now in the hospital taking treatment at Nimans. Then law says that much of time spent by you for treatment on account of disability will be added to file the suit, but you have to prove it. You have to show records. So 6th of Act says that disability caused on account of a given thing, that is disability is caused because of the suit is to be filed by a minor or by a man who is insane or an idiot. Once the disability has stopped or ceased to be there, then the particular thing is there is extension of time to file the suit. And for minors, they can file suits through their minor guardian. So as per Hindu law, as per Guardianship and Wards Act, or even the court may appoint a man as a court guardian. So plaintiff is a minor, suit is filed against a particular defendant on a note or recovery, then guardian may file suit on behalf of the particular minor or even a man under disability. Then 7 is disability of one of the several persons, not important. Then the next point is how to compute the period of limitation. Date of loan is 11/2017. What about time limit for me to file suit? The limit is 3 years. How to compute this period of 3 years? Simple question of arithmetics. Sometimes I cause mistake. I commit mistake. Very silly mistake. So how to compute the time of limitation? So that states that exclude the date on which you file suit in the court. That date you have to exclude. And if you exclude it, you must come within the period of limitation. If it is there means that's a within time file petition. So 12 says exclude the date on which you file in court the petition. So sometimes advocates, they make wrong calculation. They file case the next day after the suit becomes time bar. Then 13 is, I file a suit in the court on the point that I'm a pauper. I don't know, means to pay court fee. Court says that you're rich, you got bank balance. Court says your petition for leave to file suit as a pauper person is dismissed. They say you go to court and you no pay court fee. For him, what about the time spent by him to pursue the petition filed by him for leave to declare him as a pauper person? So time spent by that person to pursue the particular relief of grant of permission to file suit without payment of court fee is excluded. And what pay court fee and the suit goes forward. So with this, the next point is, in case of a demand promissory note, suit based on check, or in a case wherein there is a agreement on which money is lent, then the time limit is within 3 years for a file suit under section 19 of the Act. So 19 says file suit based on the note, based on agreement, date of loan, within 3 years you file suit. Then 18 of the Act is, I am the borrower, X is the lender. The borrower pays to the lender rupees 1 lakh, say last year. What about time limit for me to file suit? any part payment made by the defendant to the plaintiff or the lender will extend a further time by 3 more years. That is 18 of the Act. That is the 19 of the Act. Any part payment made by the particular person will extend time by 3 more years. That is 19 of the Act. And 18 is any person saying now that I will pay the debt, give me two months or 3 more months. He executes what's called as acknowledgement of debt in writing. So we got it as AOD. AOD will grant time of further 3 years from that date under section 18 of the Law of Limitation. 19 is part payment will extend time by 3 more years. Bankers, they invoke this clause. By mistake, suits are not filed within 3 years. What the banker will do, will see the account extract. Payment made on a given date, take a copy, take paying slip, and from that date, they just add 3 more years, then the file got a suit. So with this, the next important point is the schedule. So for our money suit, the schedule is the part 1 of the schedule to the Law of Limitation. Article 1 speaks of balance of dues on accounts. And for us, the aspect is what to file suit within a period of 3 years from date of loan. So as per schedule, as per part 1, suits for recovery amount, it is 3 years from date of loan, date of payment, date of agreement. So for money suits, which we are discussing, the time limit is 3 years as per part 1 of the schedule to the Law of Limitation. So with this, I think I have completed the aspect of the main study. I think I have overshot. I think I am late. In fact, Vikas told we can speak up to 6 o'clock, and I have touched now it is 6:30 because there are more law college students. I could see them because they are very, very young. Last batch we saw only middle-aged and older persons. But today I'm seeing young to become advocates, law college students. So I made myself clear on the aspect of these important law segments, and it is a very vast subject condensed within a matter of 1 hour 45 minutes. If you got doubts or any queries, you may kindly ask me. As the organizers, Dr. Mallikarjun says, or Sri Vilas Charan says, we'll just go forward as they tell us. Yes,
So I think that since we have already overshot the time, the session of question and answers will take further 2.5, 3 hours. And because the lawyers will have a difficulty. We will have another session on the questions. Rather, I will ask Mr.
Okay, they can do one more thing. They can contact me. You can just give them my mobile number.
No, we would rather bring you on the platform again.
Yeah, that I am there to answer.
Yes, sir. Yes, sir.
Because sometimes, see, they may get some doubts, say, after some time.
So in case anyone shares me on the WhatsApp, I will share it with you on the WhatsApp.
So
Yes,
that's
sir.
fine, sir.
Yes.
So I'm very glad to see all of you on the screen, online, and that what I told is, just a bird's eye view, because as you all know, one order of the CPC, we can tell 2 hours. And as told by Vikas, yes, we want one more session of 2 hours or 3 hours only for answering questions of the advocates and students.
Yes, sir. That's what I told you. Normally, we'll take into 1 hour each so that the people can also participate in their office also. And before we part for the day, I'll request Dr. Mallikarjun and Mr. We are also thankful to Mr. Manoj, who was the connecting point, to propose a vote of thanks before he formally proposes. Only I'm just announcing the tomorrow session. Tomorrow's session will be gift under the Transfer of Property Act 1882 by Mr. S. Mukant, an advocate from the Madras High Court. So do stay connected with us tomorrow at 5:30 p.m. And over to Mr. Mallikarjun. It was a pleasure connecting with KLE College and have been told that he is himself also an excellent speaker on administrative law and constitutional law. We'll also request him subsequently for his session. Over to you, sir.
Mr. Vikas, we can rope in Dr. Mallikarjun for your lectures on some very good legal topics. Yes. And he has made research on exam.
Sir, I'm sorry, I got myself muted. What were you saying?
You can rope in Dr. Mallikarjun for some webinars. In fact, he is a doctorate on the point, on the subject on which he has contributed for his thesis. You can ask him to speak, or even other topics which are purely theoretical. I spoke about legal rights.
Sir, we will not rope in, but we will say that there is a judicial order passed by Mr. Vishwanathan, so you have to comply with it.
No, sir. Okay, sir. Thank you, sir.
Yes, sir. Over to you, Mr. Malika.
Yes, thank you, Vikas. At the outset, sir, I thank you profusely for over 2 hours of exhaustive talk on this topic of the recovery of money and Limitation Act and so many nuances of litigation practice you have covered. In fact, there was an unspoken understanding between myself and Vikas not to stop you at any point of time, so that we can have a reservoir of information that will be stored with us and we can go back and listen again and again and understand. Hope Vikas will agree with this unspoken understanding that we had. And hence, sir, I profusely thank you on behalf of Beyond Law CLC and also KLE Society's Law College. And thank you very much for putting across Vikas and KLE and believing that joining together, we can contribute in a dissemination of very relevant information. And we'll make this our starting point. And as Vikas said, we will consider it as a judicial order to take it forward very judiciously. Thank you so much, sir.
In Hindi, there's a wording, they say that Aghaz acha hai to anjam bhi acha hoga. If the starting is good, the beginning would also be good. So do stay connected with us tomorrow at 4:30, and I will talk to you, Dr. Mallikarjun, after the session. Thank you.
Thank you.
Thank you so much.